continue with trademarks. I forgot to put my name on it, but my name is Natalie Nathon. I'm a colleague of Nuno, and I will present quickly, and we ask Gonzalo to, if I am out of time, tell me that you have 2 minutes to discuss, because of course, we have many presentations today to listen to. So trademarks and GIs are related, industrial property rights, and I call them brothers and sisters. Of course, there are differences, but a lot of similarity. And I would like to show a little bit what are the rules in the EU, and a little bit the case law if we have time. Trademarks in the European Union is rather complex. There are several ways to protect trademarks at domestic level, at national level. So the member states have their own trademark. They have their own EU. They have their own offices, and of course, we have one regional office, which is the Benelux countries. So there is only one regional registration. Belgium, Netherlands, and Luxembourg has one IP office. There is the EU trademark, the EU-wide protection, all EU member states via EU IPO in Alicante. And of course, we have the international registration via WIPO. This is also the difference between what we heard from Nuno on GIs. In GIs, we have a sui generis system, an exhaustive system, one application protection in the whole territory of the EU. For trademarks, as you see, is a little bit fragmented. It's a little bit different. Here, some examples, because we will concentrate a little bit on collective and certification trademark today. I will speak less on individual trademarks. At the end of my slides, there are some marketing strategies to show a little bit how certain producers accumulate the logos and protection for a given GI term. So we have some Platano de Canarias, some banana from the Canary Island, Grana Padano, Italian cheese, and Cereza del Jerte. All these are collective trademarks. And as an example, for certification trademarks, one is for halal, and the other is for panettone, the famous Italian cake, which I saw in many shops in Kuala Lumpur as well. So those are the certification trademarks examples. If we look a little bit about the differentiation, we see individual IP rights, of course, individual trademarks, and we have the shared IP rights, collective certification trademarks, and geographical indications. I have to flag that geographical indications are collective rights. Obviously, there are some similarity with collective and certification marks with these many different rules. Certification and collective trademarks, especially certification marks, was introduced as of 2017 at EU level, so it's relatively new. Some of the member states had and has still. So there is no harmonization in that sense. Member states could have chosen to not implement in their system, but some of them still has, and there are also, due to this, some discrepancies. But now I will explain the harmonization also in relation to certification trademarks, collective marks, and GIs. This is something which I don't need to explain, because all of us know what are the differences between and what are the role or the function, the differences between geographic indications and trademarks. Obviously, for GIs is, and I won't repeat Nuno's excellent word, it's about cultural heritage. I also call it emotional brand, the GIs. It's also very linked to a territory, to a country. It's a national pride. Trademarks are more like a business-oriented industrial property right. It's about commercial origin, to to protect brand identity and also to enhance consumer loyalty. So the function is different. If we compare in the EU, the protection, GIs, as Nuno also mentioned, is one registration and the protection is forever. Trademarks shall be renewed every 10 years, the protection at EU level. Here, an example of collective trademarks and GIs, and I also mentioned here the branding strategy. Some of these trademarks are registered. This too is registered, but we have a kind of collective trademarks also included in the product specification under the heading labeling. So, and this is something which currently there is an ongoing case dealing with the accumulation of signs. Some of the producers group, such as the case of Aceto Balsamico di Modena, the second one, oblige all its members to put on the labeling this sign. Collective trademarks, and I know all of us probably knows the basic rule. It's about a commercial origin of certain goods by informing the consumer that the producer of the goods provider belongs to a certain association. It's it's important to say that it's not obligatory in the EU to be part of a producers group. So it's optional. So in case the producers group has a collective trademark, obviously those producers who are outside the producers group might not be able to use the collective trademark. There are ongoing discussion on this as well at EU level. And sometimes, for example, for Bordeaux wine, there are several producers groups. So in the same region, there are, to my knowledge, there are at least two producers group, but they produce the Bordeaux wine complying with the product specification. I already flagged that some of the collective mark are used together with their own individual mark or geographic indication or and. We will see an example at the end of my slides. It means that the producers group, individual producers want to differentiate themselves on the market. For example, for Champagne, Dom Perignon, the producers, obviously Dom Perignon is an individual trademark. They want to differentiate among the producers, even if producing the same product, their uniqueness or their brand. Collective trademarks can designate the geographical origin, but it should also be capable of fulfilling the essential function. So for trademark application, whether it's collective certification on individual trademarks, the rule for scrutinizing are the same in a sense that it should be capable and to indicate the commercial origin of the goods sold under the trademark. Obviously, there is also a regulation of use which should be attached to the application and is uploaded also on the homepage of EU IPO, the EU IP office. Here, the case I mentioned, it's brand new. We are waiting for the interpretation of EU IPO First Board of Appeal because it was a referral to the Grant Board when there is a question of interpretation of law. There is this referral. It's very new because it's from 7th of July 2025. The case, it's about Selva Cremasco. It's an Italian cheese, and it's about the accumulation of sign, basically, that this logo you see on the top is also included in the product specification, and they also submitted application for protection of collective trademark. So maybe in a half a year or maybe more, it depends whether the decision of EU IPO will be challenged at the Court of Justice in Luxembourg. We will know a little bit more on the accumulation of sign in relation to GIs. Here, it's about the protection not of the GI but the collective trademark on the packaging. It's I mentioned this case because it's going towards a new case law, and let's say if this case go ahead, it might change also the guidelines of EU IPO. This is why this case is now everybody's waiting what will happen, because it will create precedent. In case, as I mentioned, there is a collective mark application. If the collective mark includes only the GI, it cannot be registered. GIs, as we know, are descriptive terms. So alone, it cannot be registered as an individual word trademark. And we have a precedent case from the Court of Justice, the Halloumi case, which clearly indicate that it should include verbal figurative elements. So no word trademark, including only the GI, but figurative trademark. And also, if it includes the GI, it should be a limitation in the classification of the NIS classification that the collective trademark will be used for X, Y, Z GI for a given cheese, which comply with the product specification. So if there is no limitation, it will be rejected, or EU IPO will ask for modification of the application. Quickly on certification trademark, just to reinforce what Nuno said, is that we have a sui generis exhaustive system. This exhaustive system was the case law of Budajovicka Budvar Budweiser, which was clearly stating that there is one system in place, the sui generis system. There can be not in parallel any other system. So certification trademark GIs cannot be protected through certification trademarks in the EU to avoid several venues. We know, all of us, very well that the TRIPS agreement gives the possibility to implement through trademark, through sui generis, or through administrative decision, the GI clauses, but in the EU, for the coherence, only sui generis system can be used. Here, you can easily ask the question, what happens with the craft and industrial product? As you know, as of 1st of December, we will have the new system in place. And indeed, before this system was in place, the regulation entered into force last year, applied as of 1st of December 2025. But what happened before? Some of the member states, let's say not many, but some of the member states already had certification trademark in place or sui generis system for CGIs. So we might have some certification trademark at member states level for CGIs. This should be the member state, but we will hear a presentation today, will have a year to submit to EU IPO the application for handicrafts. And this will be converted because certification trademark cannot be anymore the legal basis for CGI, craft and industrial product GI protection. A little bit on the absolute grants of refusal and the relative grants of refusal, also because we talked today about international negotiation, and also because it's very important that all trademark application which is after a GI application submitted to EU IPO or any member state's IP office, it can be either through international agreement or through direct application, they will be rejected if it's conflict, if it's identical for comparable goods with the earlier GI application. Regardless of PD or PGI, here, as Nuno also mentioned, we have two types of GIs. Here, it's in that context, it's only geographic indications. So it's the common category is used, and the GI view include all the bilateral and multilateral agreements or plurilateral agreements, because we have with Andean, we have some regional agreements. The priority date, what the IP offices are looking, the priority date is what is listed in GI view. I just took a screenshot. As an example, this is the wine we protect from New Zealand, and you see priority date on the right side. This is the date to be used as a priority date. Also, all our negotiating partners and with whom we have concluded agreement can have access to GI view and upload data. So in that case, New Zealand can upload under each of these GI additional information to help customs or law enforcement bodies to enforce. So this is a living structure, GI view. Even the member state have access. So it's something which helps a lot in the enforcement of GI rights. I'm not repeating myself, so it's just quickly GI view. eAmbrosia is the official register. GI view is all the data in eAmbrosia is accessible through GI view, and also all the GI listed through trade agreement. Let's not forget the Geneva Act of the Lisbon system, because they are also included in GI view. This is just a reminder of the current regulation. We saw these, some of these in the slides of Nuno, just to flag the Article 1G on the trademark regulation in relation to GIs. So what happens if there is when we negotiate a bilateral agreement? We receive the list of GIs from our trading partners. Every month, we inform EU IPO and all member states. This is the GI to be protected under the bilateral agreement, or to be protected under the Geneva Act of the Lisbon Agreement. This, in that case, EU IPO, it depends whether I mean, usually the GIs mature into registration or protection. So they suspend the examination proceeding, waiting of the outcome of the GI. So it can, it's something which we have regular meetings and regular exchange with the IPO on this, is to avoid bad faith application, trademark application, or bad faith registration. So there is a suspension, the examination proceedings until the GI registration or protection proceedings are concluded. The ex officio, because we are still at the absolute grants, the ex officio examination is limited to goods identical to the product covered by the GI, or certain case-specific object of services as retail or wholesale or import-export. Just already to flag, we are reviewing currently the guidelines of EU IPO. So although this won't change, but by next year, there will be an updated guidelines with the case law, because there is a lot of case law. And these excellent guidelines help us also a lot on our everyday work. So goods comparable to the product covered by the GI, and goods in which the GI is a relevant ingredient. We had not a lot of case. There was one Café de Colombia where it was an application for chocolate, where the use was the chocolate relevant ingredient was Café de Colombia. It was included under the NIS classification in the heading. Finally, there was an opposition from Café de Colombia, but the applicant and Café de Colombia GI producers group agreed, and the application for trademark was withdrawn. So, but there is few cases regarding ingredients. When it's about non-comparable goods and services, ex officio rejection cannot be applied. In that case, it will be published for opposition. One of the reasons behind for opposition can be the reputation of the protected name. And we have here not only the already referred Budweiser case, which was clearly included the exhaustive system of the EU GI system, but also that this exploitation of reputation covers also services and everything which exploit the reputation. In May, June, there is a new judgment of the court, final judgment. It was not appealed, the famous Nero Champagne case, which was based on Article 8.6. It was about a company who had an Italian hotels chain called Nero, who also, although they limited the product specification to GI, to commercialize champagne who complies with the product specification, it was not enough for the court because it misled the consumer. Nero Champagne, it interpreted in a way that probably the champagne is, knowing that we have rosé champagne, Nero Champagne refers to the color. Of course, it's only just one element of the case. Currently, since September, October, there is a lot of article analysis of this case. This, I can already say it's included in the guidelines of EU IPO, but of course, it's a groundbreaking case in a sense that even if the NIS heading was limited to a genuine product, it was not enough. There was not enough persuasion that this would not fully exploit or even dilute, because dilution was used by Champagne in his observations. Again, something important to flag that GIs per se are considered having reputation. So reputation of GI should be not established. It is something that if a GI is registered, if a GI is protected, it is considered having reputation. It's up to the in case of a litigation to prove how this reputation is exploited. And this is also one of the most important cases, the Port Charlotte. It was the Porto wine case. You see there are clear rules that the opponents should, in that case was the Porto wine producer, they should not submit evidence of the reputation, but they need convincing argument regarding the exploitation of the reputation. So it's something which the court follows, and as everywhere, case law can change and improve. So this has been improved now with the Nero Champagne case. Another example was the Citricos Valencianos, which is a GI protected for orange, lemon, mandarin. And you see partially the contested sign include the name of the GI. However, it was for essential oil and food flavoring, the application. Here, the conclusion of EU IPO was that the relevant consumer will probably associate the GI and the goods it covers. So it was rejected, the contested sign. And a little bit at the end, the 2 slides on the marketing strategies. Here we see a Parmigiano Reggiano with 4 logos. We see the Consorzio Vacche Rosse, which is the producers group within the Parmigiano Reggiano producers. So it's the same region, they produce genuine products. Parmigiano Reggiano in the product specification clearly states that in every packaging, the Consorzio, the producers group logo should be there. It's also protected as a trademark. Consorzio Vacche Rosse is also protected as a trademark. And we have the Parmigiano Reggiano GI. And to complicate the another logo, you see in the right side, the red, yellow EU GI logo, the PDO logo, which is obligatory. So in the EU, for foodstuff, the use of EU GI logo is obligatory. If there is no logo, there is an infringement. And for wine and spirits, it's optional. So it's voluntary, but for foodstuff, there is an obligation. So the controller instantly see if there is infringement or not. Here, individual trademark, as I mentioned before, the Dom Perignon, here the vodka of Finland, and Finlandia is the brand. So, but I can mention mainly some of the examples for alcoholic beverages. Absolute Vodka, the Swedish brand, is a GI. It's Swedish vodka. They are obliged to label and put on the label Svenska vodka, so the Swedish vodka. And of course, Absolute Vodka you see in a much bigger letter. So this is how they differentiate themselves. But I have to say that in case of Swedish vodka, there is the main producers is Absolute Vodka, so there is no real competition, at least not within Sweden. Here, Rioja wine, collective trademark. The producers group is similar than Parmigiano Reggiano. There is an obligation to use the logo. I think there might be some derogation because you won't see in every bottles. Wine producer said there is no place to put all the time these logos, but you can see on their homepage, some of these wine producers have their own homepage. Here the brand name is Antea. So here within the Rioja wine producers group, they can differentiate themselves through their own individual trademark. I hope I kept the time. Thank you very much.